Good afternoon, everyone. I'd just like to start off and apologise for the delay in getting this webinar up and running. We unfortunately had some unforeseen technical difficulties, which has pushed us back. So yeah, again, I'm so sorry about that. We will be recording this webinar and we will be sending out the recording to everyone who has signed up. So you'll receive that in the next couple of days. So thank you again for joining us. We really appreciate your time, and I will hand you over to Thomas and Naomi from Naomi Corn Associates. Thank you.
Thank you very, very much. Well, it's my pleasure to welcome you all this afternoon to this session on the role of a data protection officer. My name, as already previously mentioned, is Thomas Hood. I am the Intellectual Property Officer at Naomi Corn Associates, and it's my absolute delight to welcome our presenter, Naomi Corn, CEO and founder of Naomi Corn Associates, and she is also one of the UK's leading experts in copyright, data protection and licensing. So I will now pass over to Naomi.
Lovely. Thank you very much indeed, Thomas, and thank you very much indeed, Grace, for starting the session off again. Our apologies that we're running slightly later due to some technical issues. What we'll be doing today is I'll be giving you a presentation for about 40-45 minutes, and then we're going to open the floor for questions. So please do feel free to add your questions to the chat box, which Thomas will read out to me at the end of today's webinar. So today we're going to be looking at the role of a data protection officer. We're going to just start off with a sort of gentle bit of housekeeping and some further links. So your microphones are muted, and also I can only see myself at the moment talking. Please be, as I said, as free as you like in terms of the types of questions that you add to the chat box. It's just a simple bit of netiquette from us to remind you about the tone of your questions, and also the making sure that you are aware of sort of politeness and kindness when you are posting messages in the chat box as well. There will be links given at the end of today's presentation, but certainly to start you off on your way, a couple of places that have lots and lots of content. First of all, our own website, naomicorn.com, and that contains a useful set of resources on data protection and also copyright, and you can reuse those resources for your own enjoyment, but also they are all available under a very open license. I'm also going to be directing you to the ICO, and I'll be telling you more about them as we go through today's presentation. They are the UK's regulatory body. The presentation will be sent to you in advance or subsequent to today's webinar, and it can be reused by yourselves for your non-commercial purposes. So the objectives of today, we want to give you a very good overview of data protection through the lens of the role of a data protection officer. We're going to be looking at what a data protection officer does, and also discuss together the ways in which you as an organisation can provide for a data protection officer role. And by the end, you will hopefully have a better idea of what you need to do next regarding an action plan for your DPO. And I'll be looking at that in more detail towards the end of the presentation. Thomas was very kind indeed with his introduction. I am very proud of the company that I've built up over the last 20 years. We have spent a lot of time and effort in supporting our sector, the sector that we love, become more efficient in how it deals with legal compliance issues, and also to try and develop an understanding of these issues so that our colleagues have the skills and confidence in order to make sure that when they are embarking upon new and creative projects, that they understand their legal compliance obligations. So please do check out what we do. And as I said, we've got a bunch of resources you can download for free. We also have a newsletter you can sign up to that comes through to you monthly, and we generally try and publish 2 to 3 blog posts every month about issues as they affect the sector that we love. I wanted to set the scene a little bit before we start drilling down into the role of a data protection officer, and just remind you about how much we are using technology as part of our day-to-day work. And this has become particularly evident during lockdown, when we have been absolutely dependent on a robust digital infrastructure to support our activities. And we've been I think, very aware over the last 2.5 years or so in how much technological solutions support how we're able to collaborate with each other, with our colleagues, with our volunteers, with our trustees, with our users, and with people all over the world. And we have been using and maxing out actually on not just different pieces of kit that we might have in order to rapidly be able to work from home, but also different platforms of delivery. Interestingly, I would say that our digital literacy levels have greatly improved since lockdown, but no matter what we're using and how we're using the equipment, we still need to remember that our legal compliance issues are as important as they were when perhaps we were office-based. We need to remind ourselves that, if anything, working more remotely brings into sharp relief the importance of understanding the correlation between privacy rights and online security. Now, there is more to say about this in general terms. It's slightly beyond the theme of today, although we will be looking a little bit at this through the role of a DPO in your organisation. But I'd like to already point you to a guide that we wrote on online security and privacy, which we wrote on behalf of the National Lottery Heritage Fund. There is a link that's given at the end of this presentation. Very shortly, I'm going to be putting a poll up for you just to check your levels of understanding. But before I do that, I would like to just make sure that you understand that when we're talking about the data protection legislation, we are talking about the legislation in place in the UK. And so we are very specific about the UK's GDPR, General Protection Regulation, and also the Data Protection Act of 2018. These are the main pieces of legislation that we are dependent on. Now, my first poll for you to check your understanding is I would like you to tell me what you think ICO stands for. So is the answer A, the Independent Commissioner's Office, B, the Information Content Officer, C, the Information Commissioner's Office, or D, the Independent Content Officer? Because this is going to be an important point as we go through the webinar today in understanding the role of a data protection officer. So if you would like to add your answers to the poll now, please, if we can open the poll and give you a chance to add your answers, I'll give you about 30 seconds. Over to you. Thank you. So just to make sure that the poll is launched, and if you would like to add your answers to the poll. Okay. Brilliant. Okay, so we've had, there are 18 of you joining us today, which is great. So we've had a sort of variable range of answers. So 11% of you think that it's the Independent Commissioner's Office. We have 6% of you think it's the Information Content Officer. 78% of you think it's the Information Commissioner's Office. And we have 6% of you think it's the Independent Content Officer. The answer is C. Okay, so if we could share the results, please. The answer is C. ICO stands for the Information Commissioner's Office. They are the UK's regulatory body, and they are the folk that are in charge of the data protection legislation. And for some of you, other pieces of legislation to which you may be subject, including FOI, the Freedom of Information Act. Okay, so let's kind of put a little bit of this into context. I'm going to unpick data protection law for you, spend about the next 10 minutes or so, and that will provide the basis of us understanding the role of a data protection officer. Some of you may be thinking, well, if we've got the Data Protection Act in the UK, why have we also got GDPR? Some of you who perhaps know a little bit more about data protection may also be asking the question, well, we've had data protection laws in place since actually 1984, updated in 1998. Why did we need to change the legislative framework? Well, generally speaking, the reason why GDPR was so important, and also the changes to the Data Protection Act that we had in existence in the UK, is because technology has been moving at a faster pace than legislative change. Therefore, there is, generally speaking, much more that you can do with technology than the law allows, or put it another way, that enables the necessary legal compliance framework to be in place that respects the privacy rights of individuals. One of the impacts of having laws that don't quite move fast enough, particularly when we're talking about data protection, is that data has been referred to as the new black gold, in that it's provided the means for companies to build very successful business models using data, or in other words, the commoditization of personal data. And this is really why changes to the legislative framework was so important within the guise of GDPR that originated in the EU. And for those of you who may be questioning, well, we've left the EU, we've got Brexit, surely we don't have GDPR anymore. The answer is wrong, because GDPR became, at the point of Brexit, UK GDPR at the moment is the same as GDPR across the EU. And its aim is to increase the responsibilities of people who process personal data, but also increase the rights of those whose personal data is being processed. Now, that's our sort of general introduction to data protection laws. There's a lot to say in there about accountability and transparency, raising the bar of best practice. But ultimately, why is data protection important? Well, some key points are: data protection is important to understand because we have to understand that this is a legal compliance obligation on behalf of our organizations. It's also about making sure that we minimize the chances of fines, reputational damage. But perhaps one of the most important points about data protection legislation, and perhaps for some of you who are joining us today, is that this is about respecting the privacy rights of individuals. And I often like to draw into this the correlation between safeguarding responsibilities that we have as cultural heritage organisations, the way we look after young people, vulnerable adults, people who come to our doors, people we engage with, whether it's on site or virtually, but also recognising that the way in which we treat them should be to the same level that we respect their privacy, that we look after personal data that we hold about them. So if you like, this isn't just about compliance, there's also a very strong ethical dimension to this as well. So what is the type of information that we are likely to process about people that we engage with? And this is a very general term that I've used. People we engage with could include our employees, our volunteers, our trustees, members of the public, visitors to our premises, visitors to our website, people who engage with our activities, people who hire our spaces, people who buy our products. Well, the types of personal data we are likely to collect or process would include people's names and addresses, contact details. It might also include opinions that we're expressing about an individual. But of course, within our cultural heritage spaces, it's not just the corporate personal data, if you like, that we're collecting. There may well be personal data that's held within our collection items, perhaps within letters, people's addresses, images of people that appear in films and photographs, perhaps even within artworks that we have in our collection. So there's a full range of personal data that we are collecting about living identifiable people. And this is the key thing here. We may also be collecting, perhaps as part of our extra responsibilities, to make sure that we create environments that support inclusion and diversity, perhaps information that relate to people's ethnicity, political opinions, health, sexuality, religious beliefs, and genetic and biometric data. And this is classed as special category information. It's information that people find or would believe to be private about themselves, that would be particularly aggrieved if it was made widely available. And indeed, the law, the Data Protection Act of 2018 and UK GDPR have an even higher bar for ensuring that those organisations that are collecting this type of information are even more careful about the information that they keep, that they collect, that they process. Now, within the frame of the data protection legislation, there are 6 lawful grounds for processing of this information. And these include a lawful grounds for processing because it fulfills a legal obligation. And this might include perhaps within your organisation, the accounting practices of your finance department, perhaps processing of people's personal data in order to pay them a pension. It might include employee rights. It might include your responsibilities under the equal opportunities legislation we have in place. It might even include processing of people's personal data for the purposes of seeking copyright permission. This is a lawful grounds for processing. As organisations, we need to understand not only what we're collecting, but why we're collecting it. The second lawful grounds for processing is vital interests, and this is generally classed as, if you like, a life or death situation. If you as an organisation were operating COVID restrictions, perhaps checking the COVID status of staff or volunteers, or perhaps other types of medical attention that various people visiting your premises might require, or indeed it could even be dietary needs or medical needs. This is a lawful grounds for processing that would legitimise the collecting of personal data for this process. Our third lawful grounds for processing is public task. This is defined as being the processing necessary for the performance of a task carried out in the public interest. Now, some of you will benefit from the specific lawful grounds for processing, particularly if you are a local authority funded cultural heritage organisation, perhaps also maybe a national organisation that's funded by DCMS. Generally speaking, the easiest way, I guess, to understand whether you are likely to benefit from this lawful grounds for processing is that if you are an organisation that is FOIable, so is a recipient of freedom of information requests, then it's very likely indeed that you will benefit from the public task lawful grounds for processing. But that's not all. We have others. We've got 3 more to go. And there's a reason why I'm going to be going through this within the context of the role of a DPO, which will all become clear very, very soon. We have another lawful grounds for processing, which is contractual. So perhaps you're bringing in third parties to carry out services on your behalf. During the performance of the contract, that is the basis, that is the rationale for the processing of personal data about them. It could be an employment contract, it could be a supplying contract. Is another basis for you to justify the processing of personal data. Legitimate interest is our 5th. This is a general catch-all. It's a lot more woolly than some of the others. That in itself can be helpful for determining whether you as an organisation can process personal data. There is quite usefully on the ICO's website a wizard that you can use to give you some greater understanding and depth of knowledge about whether the legitimate interests, lawful grounds for processing would apply to your processing of personal data. Now, if none of the 5 that we've gone through apply, then this is where you would use consent. This is where you would find an opportunity to seek active consent on an opt-in basis from those people whose personal data you wish to process. This should be clear and transparent. It's important to understand that consent can be redacted. It can also be rejected at the point of request. And this is absolutely and entirely within the data subjects, i.e. the people whose personal data you're wishing to process, rights to do so. From a general point of use of the lawful grounds for processing, it's more sensible to go for one of the other 5 first before you go for consent. But consent is the absolute go-to way of making sure you have a lawful grounds of processing if one of the other 5 does not apply. Now, within the provisions of the data protection legislation are a series of principles. These lie at the heart of the data protection legislation. They set out right at the beginning of the legislation in order to inform how the data protection principles should be applied. Rather than provide hard and fast rules, they very much embody the spirit of the general data protection regime, and compliance with the spirit of these key principles is therefore a fundamental building block for good data protection practice, and really starts to exemplify the importance, therefore, of a data protection officer within your organization for understanding not just what's personal data and the lawful grounds for processing, but also understanding what these principles say and how they operate within the frame and fabric of what you're doing. And here they are. Contained within Article 5 of UK GDPR, the 7 principles which provide these building blocks include the need to ensure that processing of people's personal data fulfills the requirements of lawfulness, fairness, and transparency. That they're very much catered to the purpose to which, or the processing of personal data is very much catered to the purpose to which you are processing personal data. That the data you are processing is accurate, that you know where you're holding that data, that you're holding it safe, and ultimately you as the entity that makes the decision that personal data is being processed has the highest level of accountability for doing so. Within the frame of the legislation, and I've referred to data subjects already, is also recognizing that those people whose personal data you are processing have data subject rights. Some of you may be aware of a DSARS, a data subject access request. So if you are processing people's personal data, those people have the right to access the data that you're processing about them, but there are also other data rights which are included in this list. So the right to be informed, the right of rectification or changing of the data that you hold, the right to delete data, the right to restrict processing, etc. So these are important rights contained within the frame of the data protection legislation. Now, again, setting the scene and helping us understand the role of the DPO is really at the highest level recognizing, as I've already intimated, that the entity who makes decisions about how and why personal data is processed is classed as a data controller, and they are ultimately responsible to the Information Commissioner's Office for ensuring that they fulfill the data protection principles, that they understand the lawful grounds for processing. Part of the role of a data controller is also to take responsibility for the behaviours of their data processors, and data processors by law are defined as the entities who may be processing data on behalf of the data controller. So that could be an individual, perhaps a specialist, that could be a platform that you're using, a piece of software. It's legitimized within the legislation, but what becomes really essentially clear is that the data controller ultimately is responsible, as I said, for the behavior of its data processors and ensuring that there is a suitable contractual relationship between the data controller and the data processor. Now, another couple of areas that's important to stress, and again, we'll start wrapping in the role of a data protection officer very shortly, is that a data controller has a lawful responsibility to register on an annual basis with the Information Commissioner's Office, and also sort of as part and parcel of a bundle of responsibilities, also has responsibility for making sure that any data breaches that do occur within the organisation that are reportable are reported within the set amount of time to the Information Commissioner's Office. So this is really an opportunity to look at the area of data breaches and the role of a data controller, and time spans in terms of declaring these data breaches to the ICO. So I've given you 4 options. And again, to open the poll up, please, to give you just a minute or so to share how long you think a data controller has to declare a data breach. And there is a caveat here that either does or potentially affects the rights and freedoms of the individuals affected by the data breach. So could you please indicate whether you think the answer is A, 24 hours, B, 36 hours, C, 48 hours, or D, 72 hours. Thank you. Okay, so if we could share the results, please. Lovely. Okay, so we had 29% of you think that the answer was 24 hours, 12% of you think the answer was 36 hours, 18% of you think the answer was 48 hours, and 41% of you think the answer is 72 hours. Well, the good news is that those of you who selected D, 72 hours, you are absolutely correct. So well done, everybody. The bad news is that actually 72 hours isn't very long at all. So if you can imagine a data breach that occurs on a Friday will need to be declared on the Monday if the rights and freedoms of the individuals affected by the data breach are such that the ICO needs to be told about it. Now, there is again on the ICO website a very useful set of instructions about the declaration of data breaches. Now, this, of course, doesn't mean that you don't record this internally as well. You will need to make sure that you have the appropriate provisions in place and processes for recording data breaches. But again, the imperative, if it needs to be declared, is that it's done so within 72 hours. Great, thank you very much. So let's move on, and we start to get a sense of the complexity of the legislation and therefore the need for a data protection officer. So it's not just that this is a complicated area of law and it's a nice to have. UK GDPR requires the appointment of a data protection officer. And this is about recognizing that an area as complex and as important as an individual's privacy, or if you have many individuals that you're connecting with, multiple individuals' privacy requires a specialist. A data protection officer within your organization is the person who can help monitor internal compliance. They can help ensure that the concept of a privacy by design culture, where data protection is brought to the heart of an organization, is a reality across your organization, rather than data protection being an end thought. The law requires that indeed it's thought about as early as possible, that actually part and parcel of the role of a data protection officer is to ensure that staff have the necessary tools and awareness for them to develop a culture where privacy rights are first and foremost within the considerations of new activities, new software, systems, or anything that's new and existing across your organization. A data protection officer can be shared. So whilst every organization needs a data protection officer, it doesn't mean that you as an organization are the only people who have access to that person. It can be shared across regions, across organizations. It could be done as both a member of staff and also as on a consultancy basis. The critical point here is that the person who provides the data protection advice is an independent expert on the issues of data privacy, can make a judgment call, both with regards to compliance, but also can be the eyes and ears of the organization and have the authority to provide guidance and also suggestions with regards to doing things better with regards to data protection. And this is supported by the need within the legislation that the data protection officer reports to the highest level of management. So there is a clear line, not just of authority, but also responsibility across an organization to ensure that the necessary processes are in place, that data protection is taken very seriously across the full range of an organization's activities. And as we looked at earlier, this ranges across both corporate personal data, but there may be personal data, i.e. information about living identifiable individuals within your collection items. So we're going to go through in a bit more detail the role of a data protection officer, and this will provide the blueprint for your action plan. We have, moving ahead, we've got 2 slides that sort of divide the role of a data protection officer into sort of different columns of activities. And I'm going to run through these on a one-by-one basis to give you a better sense of what that role is all about. So the first crucial role of a data protection officer is within the provision of support and advice to colleagues across an organisation. This needs to be a named individual who has the experience and also qualifications to justify them taking the role on as a data protection officer. Within the guise of support and advice, one of the key areas at the initial phase is ensuring that an organisation carries out the necessary data protection impact assessments, or DPIAs, at the point of discussing and planning new activities or new acquisitions or new pieces of software or technology, as I've already mentioned, that include or relate or touch upon the processing of personal data, DPIA. If you like, think about a DPIA as a big risk assessment for your organisation. The second area within the frame of support and advice would also be through the provision of support for dealing with data subject access requests. Now, as a management consultancy company that specialises in data protection, we are also the acting DPOs on behalf of a number of organisations across the UK's public sector. And data subject access requests will vary in length and also complexity. We have been dealing with, for a number of our clients, a range of DSARs that can perhaps be one piece of information to some DSARs that can range up to thousands of pieces of content that require analysis and ensuring that only information that relates to the personal data requested by the individual whose personal data is included within the DSAR's request is provided. In other words, it's important to ensure that personal data relating to others is not provided to that individual who's requesting information about themselves. Otherwise, this in itself can create a data breach. And of course, there are also other nuances that need to be analysed before a data subject access request can be fully complied with. There are time limits on the data subject access request, and also that at the first instance will amount to a month, but can be extended if there is a high enough level of complexity. But this, the very action of dealing with the DSARs requires coordination, and the data protection officer is the person who should be taking the lead in coordinating the collection of information from other colleagues across perhaps multiple different databases and repositories of information as well. The second area of support with regards to the role of a DPO is ensuring that staff, trustees, and volunteers have the necessary level of training. Training should be run on a regular basis. I know many organisations who geared up towards launch of GDPR back in May of 2018 and thought that sort of job done, that was it. But actually training needs to be certainly instigated for new starters, and also staff who've been in post for a while should also receive training on an annual basis, ideally, to ensure that their skills are up to date, that there is space for questions, and also ensuring that any changes or nuances or further developments in the legislation, for example, the ICO's launch of the Children's Code, which are special provisions for those who are developing apps or technology particularly geared at children, those individuals, those staff involved perhaps in that type of work are aware of their responsibilities. Now, of course, training is also a useful device to remind staff about the imperative of complying with the data protection legislation, and some of the colleagues that we work with have done so by bringing into sharp relief organisations that perhaps have fallen foul of the ICO, i.e. organisations that have been named and shamed for not doing data protection properly. If you are moving into the role of a data protection officer and wish to receive further information about organisations who perhaps haven't properly dealt with data protection, then it's advisable that you check out the Information Commissioner's Office website, and there are a full and comprehensive list of various organisations and the reasons why they haven't fully fulfilled their compliance obligations under the data protection legislation. Okay, the third role of a data protection officer is ensuring that there are the necessary data protection policies in place. Like any policies, again, those of you who were very busy in ensuring that you have the necessary policies in place for May of 2018, it is absolutely time to revise these and ensure that they are still fit for purpose. Those of you who haven't yet got a data protection policy in place, this is the role of a data protection officer. But of course, a data protection policy is not the only policy relating to data protection that a data protection officer should be looking at. It's also strongly advisable that you have the necessary data breach policy and procedures in place, that you have a policy that relates to data subject rights, as we saw earlier, because there are a number of those, a number of procedures that would need to be followed within an organization, but also correlatory policies such as an acceptable use policy, HR policies, looking at staff handbooks, just to ensure that there is a dovetailing between the data protection principles that govern the legislation and the interpretation of the legislation, your own policies, and also the activities that run across the various things that take place across your organization. Another area for documentation review is also your privacy notices. These should be an evolving piece of work. They represent, if you like, the public statement, the statement to people that you work, not only that are employees, but also your trustees, your volunteers, members of the public, people you engage with, about how you take data protection seriously and how you comply with the legislative provisions. The privacy notices that you have on your website, or perhaps associated with individual activities that take place in your organization, should be updated in accordance with perhaps changes to how you do things, additional pieces of content that you might be processing, different platforms that you're doing. As a company, when we moved over to Zoom, we ensured that our privacy notice reflected this, and that we not only stipulated this, but also the lawful grounds for processing. And then finally, to bring to your attention the importance of your legal obligations as an organisation reflected through the work of a data protection officer, is the reviewing and monitoring of data processing activities through a record of processing activities, which is abbreviated as a ROPA. It's referred to as a ROPA, R-O-P-A. This effectively is your snapshot. This stipulates exactly what type of activities are taking place across your organization that involve the processing of personal data, the lawful basis for why you're doing so, where that personal data is being kept, how long you're holding on to it for. So the retention periods associated with the personal data. Now, there may be variabilities across your organization with regards to how long you hold on to personal data. The stipulation here is that it's as long as you need. Now, this can be something that's determined by an internal policy requirement and need, and perhaps also by other legislation. An example might be that pension-related personal data would be held on to pretty much forever, because even though staff may come and go, your organisation will still be responsible for an individual's pension. So that would fall within a very good example of a ROPA reflecting that personal data processed for the purposes of pensions would be held on to, and you can stipulate the time extent with that. Whereas there may be other types of personal data. For example, if you have a book that lists people coming and going within your organization for health and safety purposes, maybe that might only be held for whether a few days or a few weeks. Okay, so great variabilities with regards to the retention of personal data, but your ROPA is the ideal place for recording that, and that should be within the auspices of the role of a data protection officer. Okay, so 3 more sections, and shortly I will pass over to Thomas, who's kindly agreed to mediate the questions that hopefully are popping up in the chat box. So 3 more areas where a data protection officer will need to take responsibility. A data breach management role. So first of all, this is about making sure that any data breaches that take place in your organization are documented, crucially, that they are able, the data protection officer is able to ensure that there is containment of a data breach, that steps are taken to ensure that the data breach doesn't happen again, and also an analysis and perhaps reporting back to your trustees about how often the data breaches have happened across your organization, and ensuring that there is a clear line of analysis that links the data breaches perhaps to areas across an organization that can be enhanced. If a data breach needs to be recorded to the Information Commissioner's Office, it would be an expectation that the data protection officer would be that person who liaises directly with the ICO. Now, during the course of the last few years, there's been a lot of fear about what the ICO does and fear about liaising with them. But I would like to reassure you that the Information Commissioner's Office is there to provide you with support and guidance. If you are unsure about whether something is a reportable data breach, they have a hotline that you can call. You can ask them the question. It doesn't mean that you're going to be fined if you call them. And actually, if anything, if you look across the organizations that have been named and shamed for bad practices in data protection, it's generally because they haven't either put in place the necessary provisions relating to data protection, or indeed they haven't reported data breaches. The role of the ICO, if you do find that you need to report a data breach, is to work with you to contain the breach. It may be that the data breach is evidence of a much broader problem, that therefore they can lead in terms of coordinating with other authorities to contain it. And they will also be there as support in case you need to contact those affected by the data breach, and they can give you advice accordingly. The role of a data protection officer is also, and we picked up on this earlier, to ensure that if you are working with third parties who process personal data on your behalf, and if I can remind you that personal data isn't just going to be within the form of digital, it might be perhaps paper records that you have, again, corporate records, archival records, maybe you've got records that are held by a third party in safe storage. The role of a data protection officer is to ensure that there are the necessary contracts in place with your data processors. The data protection officer, therefore, you can see as well, needs to have the very highest levels of expertise to review contracts and to ensure that the necessary clauses are in place. And finally, the role of a data protection officer is also one of accountability. It's about ensuring that there are regular and ideally annual audits of compliance, that right across the organisation, that the data protection officer understands and can see that compliance, again, is first and central within an organisation's activities. The accountability requirements also extend to making sure that findings are presented back to senior management or governors. If you are within the role of a trustee for an organisation, please again be aware that data protection compliance is most probably your responsibility. The data protection officer acts as your agent to make sure that the job is being done well. And finally, as well as leading with the Information Commissioner's Office regarding data breaches or clarification of further information, the role of a data protection officer will also be to ensure that the annual registration of your organisation as a data controller is in place with the Information Commissioner's Office. So we've had a romp through data protection and also the role of a data protection officer. I hope that the plan that we've put together for you is helpful for you working out what you need to do next within your role and the sorts of expectations for that person. There are some useful resources that I've already referenced, but these are some additional links to help you. So the Information Commissioner's Office, as I said, they provide a wealth of information about data protection across the UK. We've given you their URL here. The National Cybersecurity Centre provides excellent support and advice for public and private sector organisations in avoiding computer security threats. If I can also just add to this to say that within our experience, about 95% of data breaches are caused by human error, and particularly by people CCing in the wrong people into an email message or sending personal data unencrypted. And I think that's a really good example as well of perhaps how a data protection officer can bring those issues to the fore within your organisation through regular training and awareness raising activities. Here's a link to the National Heritage Lottery Fund online privacy and security guide. Also, we're very happy to showcase the work that we've been doing for Heritage Digital. There's lots and lots of content on the Heritage Digital website that relates to data protection. Please do have a look at some of the questions that we've been answering in the recent 100 questions that we've been contributing to that's related both to data protection and also copyright. And I'd also like to showcase the National Archives Data Protection Toolkit for Archives that we were very proud to develop on behalf of the TNA. And there's a link in this presentation. It's a very useful self-guided learning journey through data protection, and also particularly the relationship between data protection and other pieces of legislation. If you've got lots of cash to splash, please do buy our book. Lots of stuff in the book you can download for free from all these other resources. But if you do want it in a nice package, this is the book that I wrote with my colleagues Charles and Adrienne, looking at information law in general, which covers copyright and FOI as well. And this is how you can contact us. I'm really pleased that our cat Boo has made a guest appearance today at the webinar. And now it's with great delight to pass over to Thomas and to pick up on some of your questions. Thank you for listening.
Thank you very, very much, Naomi. To go straight into questions in the recognition of time, there's one question that's come through that's been asked by one of the attendees. It says, I'm sure that I read somewhere that registering with the ICO was not necessary if your organisation was a small organisation. So does it matter how big or small your organisation is in terms of registering with the ICO?
Okay, that's a really great question. Thank you. There are some organisations that will be exempt from registering, but it would be the role of your data protection officer to check with the ICO and check on the ICO's website if you fall within those parameters. It's not just about the size of your organisation, it's also about the level of processing of personal data that takes place across your organisation. And almost certainly, if you have CCTV cameras in your organisation, then there's a strong likelihood that you would need to register as a data controller. So it's not really enough just to say, well, we're a small charity, therefore we don't need to register. You will need to look into this. And quite usefully, the ICO has a wizard on its website where it asks a number of questions. And then by following the wizard, it will also give you clarification about whether you need to register with the ICO or not. It's a very small amount of money. I think we pay about £35 a year as a small business to register with ICO. So it's not going to be heaps and heaps of money anyway.
Brilliant. Thank you very, very much. Just whilst I gave everyone an opportunity to write any questions in the Q&A box, I had a question actually that came up from your conversation. You were talking about the fact that the UK, of course, is still partially bound by the GDPR, even having left the European Union. Do you think that there is scope in the foreseeable future that the current government or a future government might try and change GDPR, and if so, in what direction do you think they might take those rules?
It's a really good question, Thomas. Thank you. Well, actually, in the Queen's speech, there are a couple of indications that this is likely to happen. So, in particular, two proposed bills. The first bill is a sort of bill that builds on Brexit, and tries to create a mechanism that the UK can separate itself further from the EU. And particularly one of the sort of likelihoods of this is furthering the UK away from previous pieces of European Court of Judgment rulings, which would very much affect interpretation of UK GDPR. So again, it's to remember that at the moment, the UK has been given the status of adequacy by the EU in terms of the necessary high levels it expects when a country trades or goods or services or people sort of transient between or communicated across from the UK to the EU. Probably not expressed that very well, but the EU determined, and this is sort of, it's an obvious outcome, that because the UK effectively has GDPR as UK GDPR, the status was such that we wouldn't need to do anything in addition to that. Okay, fine. So that's a sort of like a basis for the next bit that I'm going to answer, which is the second bill that was in the Queen's speech. And this was very much positioned as, I think, the first real indication that government is considering moving us away from some of the provisions outlined within GDPR. So the data reform bill was presented, and this has actually presented the possibility that there may be downstream the removal of the mandatory need for a DPO, and also the removal of some of the role of a DPO within the guise of, for example, carrying out DPIAs, data protection impact assessments. Bills presented in the Queen's speech are not laws. They need to go through process. They can be changed along the way. Time can run out. So it doesn't mean it's a done deal that the data reform bill will become law. But it is something that we're watching. We will be letting the sector know if any changes do come into fruition that have an impact. The status, the state of play right now is that there is a legal requirement for a DPO and a legal requirement for some of those actions already identified, such as carrying out a DPIA, but this may be something that changes downstream.
Got you. So it's a bit of a wait and see and watch this space kind of mentality.
Absolutely.
Well, given that we have about 3 minutes left, there are currently no questions left in the Q&A box. So unless anyone has any final momentary questions, I will say thank you all very much for attending. Thank you, Naomi, for a fascinating conversation about GDPR. Something that I think a lot of people can appreciate might be first seen as a bit dry, but actually is really, really quite complex and needs a lot of explaining, a lot of detail, and something we all have to abide by. So thank you very, very much. Someone has said thank you for the DPO of the cat. Well, we always like please, isn't it? That's been perhaps the most challenging part of the webinar today, is actually trying to keep him sort of slightly out of picture. Thank you very much indeed, Thomas, for chairing the session and for sort of kindly making sure that we picked up on all the questions as we went through, and also to Grace, who's been behind the scenes setting up. Our apologies again for the sort of technical problems behind the scenes, but Grace was working very hard indeed to sort of create a new time slot for us. So our thanks to her for sorting that out. And to everyone that's joined us today, this is a complicated area, but I hope that I've sort of drilled down into some of the key points for you, some takeaways, a plan of action, hopefully for you to work out where to go with the DPO. Do have a look at our website at the resources that are out there. There are loads of templates we put relating to data protection. We've also published a blog post very recently by one of our senior consultants, Kit, who's talked about the data reform bill, if you want to read up more about that and what might come through. Brilliant. Thank you all so very much indeed for joining us today. And I'm officially going to end the webinar for today.